of this lecture series on the landmark judgments of the Supreme Court. Now, last month I spoke about the first fundamental rights case decided by the Supreme Court, that is A.K. Gopalan versus State of Madras. It is by now a trite opinion that Gopalan was wrongly decided and was, in a certain sense, the original sin of the Supreme Court, a sin that has long been expiated, most recently in the right to privacy judgment. But last month, I tried to argue that all these years, we've been drawing the wrong conclusions about why Gopalan was wrong. And those wrong conclusions have prevented us from understanding that the approach the Supreme Court took towards fundamental rights in Gopalan, the heart of that approach has never been overruled. And in that sense, the ghost of Gopalan is with us today. That approach can be summed up as a blurring of lines between rights and restrictions, between what is normal and what is exceptional. The Supreme Court in Gopalan began its career as the guardian of fundamental rights by normalizing the preventive detention provisions of the Constitution, by failing to treat those provisions as exceptions, and thus opening the door to many decades of what effectively became and continues to remain executive impunity in the name of public order and national security. That's as far as Gopalan goes, and that's important to set the context for today's discussion. In this second lecture, I'm going to talk about a case that arose as a direct consequence of the Gopalan judgment. A case that, in many ways, as we shall see, wrote the next chapter in the history of civil liberties at the Supreme Court in India. This is the case of State of Madras versus Vg Rao. This was a case that, in terms of outcomes, went the other way. The Supreme Court struck down a repressive law. And so in many ways, Vg Rao and Gopalan can be seen as antagonistic. And indeed, Vg Rao's formulation of what makes a restriction reasonable is a formulation that echoes down to this day. Many have argued, and I am one of them, that this was a precursor to the test of proportionality that today governs the assessment of what constitutes a reasonable restriction. And so Vg Rao is the more optimistic and the more positive story in those early days. But like with Gopalan, in this lecture, I want to complicate that story somewhat. I will try to argue that in Vg Rao, the court tried to carve out an exception to Gopalan, which, if you remember, was itself supposed to be an exception. It tried to draw a line in the sand that separated the Gopalan situation from the situation before it, and to reassert that the logic of Gopalan could not be applied everywhere. But as I will also try to show, at the end of the day, this line drawing exercise proved to be futile. Vg Rao was an invitation to the future judiciary to genuinely relegate Gopalan to the margins of constitutional discourse. But it ended up being a very half-hearted invitation that unsurprisingly was not taken up and only ended up strengthening the underlying logic of Gopalan and universalizing it. That will be the broad thrust of my argument today. Now, why do I say that there was a direct connection between Gopalan and Vg Rao? After the Gopalan judgment, where the Preventive Detention Act was upheld by the Supreme Court, you remember that, the Madras government thought to itself, hey, why don't we apply the Gopalan logic everywhere? Now, there used to exist a law called the Criminal Law Amendment Act of 1908. Note the year, 1908. This law had been passed by the colonial British regime primarily to suppress the freedom movement. And it authorized the banning of organizations if, in the opinion of the government, those organizations were involved in breaking the law, undermining public order, familiar gamut of things. Sounds familiar, doesn't it? The Madras government knew that as it stood, this law was certainly unconstitutional because it effectively made the government's subjective satisfaction final on the issue of the restriction of fundamental rights. And the Madras government knew that at the time, no court in the country, not the Madras High Court or the Supreme Court, would accept that as constitutional. So what the Madras government did was that, armed with the judgment in Gopalan, they simply amended what they thought was the offending section of the 1908 law and replaced the subjective satisfaction of the government with the preventive detention procedures of advisory boards. So the decision to ban organizations would go to an advisory board, which, in a severely truncated process, where many of the usual defenses open to criminal defendants were foreclosed, this advisory board would then decide whether or not to ratify the decision to ban the organization or to strike it down. In all other respects, that is, the actual banning of organizations, of various provisions that provided for forfeiture and confiscation of property, of the government giving itself an exemption from disclosing any material it thought was not in the public interest, the law remained exactly the same. And so what was effectively happening, as K.G. Kannabiran points out in his book, The Wages of Impunity, was that this British colonial law, designed to suppress the freedom struggle, was taken lock, stock, and barrel into independent India, plus an advisory board to act as a ratifying body. And it's interesting in this context to see what the freedom fighters had to say about this very same 1908 law. In his unpublished lecture at Gaya in 1922, then Congress Party President C.R. Das said that whenever the government invoked law and order as an excuse for suppressing fundamental rights, it was nothing more than a plea for absolutism, that there could be no law and order before a genuine rule of law actually began. And legislation such as 1908 Act was nothing more than a lawless law. When 13 years later, the 1935 Government of India Act brought partially responsible government to India, one of the first moves made by the Indian legislators was to attempt to get rid of 1908 Act. S. Satyamurthy, who was elected to the central Dominion government, brought in a bill that he called the Repressive Laws Repealing and Amending Bill, where he effectively said that now with 1935 Government of India Act, which for the first time has brought in a measure of responsible government into India, we have a clean slate. It's time to start over. It's time to get rid of all these laws. Satyamurthy said that the 1908 Act and similar such laws were passed in an anxiety to punish those against whom the executive has got suspicions, but against whom it has no evidence, and on a desire to govern this country by barbaric Russian methods, as they used to be called, whereby they want to suppress freedom of the person, freedom of the press, freedom of association. So the argument was that you don't have evidence, but you do have suspicions, you don't like someone, and so you use the cover of these broad laws to get them out of the way. Satyamurthy went on to say that if all these acts still remain upon the statute book for 50 years, even 100 years. And if after 50 years of your rule, you still want these acts, that only shows the rotten way in which you rule this country. Point being that if after many, many years, repression is still the favored method of rule, then all that says is something about the quality of that rule and not about the people who are thought to be repressed. Needless to say, these attempts were unsuccessful and these laws remained on the statute books as long as the British continued to rule us. But even after the British left, they still remained on those same statute books. And you can imagine if Satyamurthy thought 1935 Government of India Act was time for a fresh start and a clean slate, then what would you say about the Constitution of India that got rid of that came upon the end of the British rule and the beginning of self-rule? But despite all that history, here was the Criminal Law Amendment Act that survived. And not only survived, here was the Criminal Law Amendment Act with the Gopalan rule now tacked onto it. And here it was in independent India. Remember how in the last lecture, we talked about how Gopalan himself was in jail on the night of independence, hoisted the Indian flag in jail, and went in one stroke from being a prisoner of the colonial British government to being a prisoner of the Indian government. In that sense, the Criminal Law Amendment Act was the legal equivalent of what Gopalan went through. And one of the first people that the Madras government then used it to go after was Vg Rao. Now, who was Vg Rao? Vg Rao was a labor lawyer, a friend of trade unions, and a committed leftist. Vg Rao ran a society called the People's Education Society, whose charter stated that it was dedicated towards advancing scientific and rationalist consciousness, popularizing art, drama, and so on. The government accused the People's Education Society of being a front for the Communist Party, which was banned at the time, and of using the funds that it was receiving to funnel towards the Communist Party. Accordingly, the People's Education Society was banned through a government notification under the Criminal Law Amendment Act of 1908, and its funds were sought to be forfeited. This is also a familiar story, and I want to pause for a moment and reflect on the targeting of another labor lawyer and trade unionist many, many years later. That is Sudha Bharadwaj, who has now been in jail for more than 2 years without trial at the time that I say this. It seems that the more things change, the more they remain the same. Now, Vg Rao challenged this notification that banned his association and sought to forfeit all the funds. Now, when we read the judgment in Vg Rao, we mostly read the Supreme Court judgment, which is a brief 9-page long order that strikes down the Criminal Law Amendment Act. But I want to start elsewhere. I want to start with the Madras High Court, which first struck down this act and whose judgment the Supreme Court upheld. I want to start here because here is where the story actually begins. And a reading of the High Court judgment reveals quite how radical and innovative the arguments of Rao's lawyer, M.K. Nambiar, were, how the Madras High Court responded to those arguments in 52 pages of a much more detailed judgment, and therefore how in many ways the final Supreme Court judgment in Vg Rao was a missed opportunity, not for what it did, but for what it could have done and didn't do. Now, the Madras High Court bench had 3 judges, and all 3 of them wrote separate but concurring opinions, agreeing that the law was unconstitutional. Recall that what the law effectively said was that the government had the power to ban associations which, in its opinion, were interfering with law and order, undermining public order, interfering with the course of justice. the decision to ban an organization was to be sent before an advisory board, there were certain procedures that were given a go by, such as making a representation. There was no time limit on when the government could send the papers to the advisory board. There was no requirement of serving the association that was being banned. And before the advisory board itself, many of the core criminal procedural safeguards were non-existent. Any material the government felt was contrary to public interest, it need not reveal it. And the advisory board would then decide to ratify or not ratify the government's decision. And along with banning the association, its properties could be forfeited and the members could be imprisoned. That was effectively what the Criminal Law Amendment Act, with the Gopalan rule tacked onto it, sought to do. The Madras High Court bench had 3 judges, as I said, and all 3 of them wrote that the law was unconstitutional. Vg Rao made many arguments. He argued, among other things, that in setting up a wholly separate procedure for banning organizations, the law violated Article 14. That its provisions violated both the substantive content of Article 19(1)(c), the freedom of association, as well as its procedural safeguards, and that it violated Articles 19(1)(a) and 19(1)(f). Primarily, Rao lost on Article 14, won on Article 19(1)(c), and on 19(1)(a), 19(1)(f), there was no real analysis by the High Court. The state, unsurprisingly, relied upon the Gopalan judgment, saying that what was clearly upheld and judged to be constitutional in Gopalan, that's exactly what was being done here. That was the process being followed in this case. The state also relied upon another recent judgment of the Supreme Court in Dr. Khare's case, where an externment order passed under a set of procedures quite similar to Gopalan had been upheld by the Supreme Court. Externment means when you order a person to leave the jurisdictional boundaries of a particular jurisdiction, state, and be outside it for a certain period of time. So if, therefore, the High Court had to strike down this law, it first had to distinguish both the Gopalan judgment and the Khare judgment. Now, how did it do so? The lead judgment was authored by Justice Satyanarayana Rao. He did this in 2 ways. On Gopalan, he drew a distinction between the preventive and the punitive. This Criminal Law Amendment Act, he argued, was not preventive, where a wholly different set of circumstances applied: suspicion, subjective assessment of the state, and so on. This law was punitive. It effectively punished associations and punished people belonging to those associations. And so he held that the Act as amended does not provide for testing the correctness or the validity of the notification. In the ordinary manner in a court of law, where a man is accused of an offense or is thought to be deprived of his liberty, it is open to him to show that the notification in doing that was not justified. But instead of that, the Act provides a machinery for ascertaining the opinion of the advisory board as a substitute for trial under ordinary law. Thus, by an executive notification, a person is effectively prevented from showing that the association is not unlawful, which entails the consequences that he is liable to the penalties provided under the rest of the Act, which I've spoken about. So here, effectively, what he said was that, okay, in a preventive detention case, in a case where the whole structure is one of preventing a future crime, Gopalan has said that the following processes apply. But when that is not at issue, then you cannot substitute the regular machinery of criminal law for this truncated advisory board process. Secondly, on Khare's case, Justice Rao drew a distinction between the temporary and the permanent. In Dr. Khare's case, what was at issue was a Punjab Act that itself was due to expire in 1951. This was 1950 judgment. And so Justice Rao said that I think, however, that the scope of the two acts, that is the Punjab Act that was upheld in Khare's case and the Criminal Law Amendment Act at issue in this case, the scope of these two acts is entirely different. The orders contemplated under the Punjab Act are only for a limited duration, whereas the declaration under the present Act continues in force until it is cancelled by the state government. So that distinction between the temporary and the permanent became the basis of distinguishing the present case from the Supreme Court precedent in Dr. Khare's case. And in trenchant terms, Justice Rao noted that the advisory board effectively existed only to salve the conscience of the state, and he struck down the act. So this twin distinction between the temporary and the permanent and the preventive and the punitive became the twin bases of Justice Rao's lead opinion that struck down the Criminal Law Amendment Act. Now, the concurring opinion of Vishwanath Shastri J was even more interesting. He termed as unthinkable the argument that the state had any prerogative right to ban associations and imprison its members. In particular, in examining American precedent, he then went on to note that where personal rights and liberties are concerned, a wider coverage of judicial review had been accorded than in the case of the property rights, including freedom of contract. There is an hierarchy of constitutional values in which rights of personal liberty, freedom of speech, assembly, and association are accorded the first place rights. And thus, he asked, when civil liberties are up for consideration, should the traditional presumption of constitutionality even apply? But then, if not, then what was the standard that ought to apply? Justice Shastri prescribed a three-step test with three distinct prongs. And as we go through this test, you'll see it sounds very, very familiar. And remember, this is 1951. First, the first prong of the test was the purpose sought to be served by the legislation legitimate and authorized by the Constitution? In this case, the stated purpose was to maintain public order, maintain public peace, and so obviously, the purpose was legitimate. There was no question about that. Secondly, second problem: did the impugned act have a reasonable relation to that purpose? And note, he didn't use the word or phrase rational nexus. Rational nexus, which is an exceedingly low threshold of review that provides exceeding deference to the state. The phrase he used was reasonable relation. And he said that fairness of means is as indispensable as the fairness of ends. So both have to be placed on an equally important footing. Your end must be legitimate, your goal must be legitimate, but the fairness of the means is equally important, and you cannot subordinate one to the other. And to determine that fairness of means, you must examine the act in its entirety. This led him to the following conclusion, and he observed, and quoting him, "The impugned act has transgressed these permissible limits. The provisions relating to the forfeiture of movable properties, monies, securities, and bank credits of a prescribed association have little connection with the maintenance of public order. It is not merely a precautionary detention, but a forfeiture to the state, not merely of the properties of the association declared unlawful, but of other persons' properties as well, which in the opinion of the government are intended to be used for the purposes of the association. Even creditors have no right to proceed against the properties forfeited to the state. It is not so much the declaration by government that an association is unlawful as the direct and immediate consequence that might attend the declaration that are serious and far-reaching, reaching beyond the confines of public order. Such extreme penalties imposed in order that they may have not only a deterrent but a terrorizing effect would make the legislation unreasonable. Now, I want to pause here and just like think about how far we have come in the intervening years, where attachment of property and confiscation of property and all of that has become par for the course in multiple laws across the board. And the point that Justice Shastri was making here was a straightforward one. Of course, you can potentially make an argument that, oh, actually, if the association is going to be using that property for its unlawful purposes, then along with the power to ban the association, we must also have the power to confiscate the property, attach it, or whatever. So there is this kind of ever-reaching chain that keeps going until you are able to, in your view as the state, completely suppress the association. Justice Shastri, on the other hand, said that there has to be a very clear and confined limit to how far you're going, which is what he meant by fairness of means and a reasonable relation between the end and the means. And that has to be policed by the courts. So if your goal is to maintain public order, that goal is served by banning the association and taking action against its members if that is what the government wants to do. But taking over properties of the association and of other people who, on the basis that it might be used, goes a step too far and violates rights. And so that strict relationship that must be maintained between the goal and the impugned act in the case of violation of rights is something that the court will actively safeguard. And I think here is where you see, in a very clear sense, an articulation of what many years later in the proportionality standard would go on to become the necessity prong, which is that you cannot violate rights to a degree greater than what is strictly required to achieve a legitimate goal. And if there is any alternative route towards that goal that infringes rights to a lesser degree, then that's the route you must take. And the more intrusive step will be struck down as unconstitutional. And that analysis is something the courts must actively undertake. You see that coming out very clearly in this concurring opinion. And so on that basis, those specific provisions involving the confiscation, forfeiture of property was struck down in this concurring judgment. And this was the only concurring judgment to specifically analyze that aspect. Then Justice Shastri went on to say that a declaration by the government upheld by the advisory board might remain operative and effective for as long a time as the government might think fit. Bodies corporate and incorporate might be put out of existence altogether and divested of their rights and their properties on a declaration by the executive. The declaration may be based only on the opinions or suspicions of the government, on the tendencies and presumed opinions of the members of the prescribed association. It is not required to be based on the overt acts or the plain omissions demonstrable in a court of law. Not only in England, but in Australia too, where there's a written constitution, it has been recently held that a state of war justified many inroads on personal freedom and restriction on the use of property of an abnormal and temporary nature, which would not be considered legitimate in times of peace. So here you have the third distinction being drawn. Distinction one in the lead judgment was between preventive and punitive. Distinction two was between the temporary and the permanent. Distinction three is between war and peace. So you have these clear lines being drawn by the High Court as to when and under what circumstances can departures be made by citing something exceptional. Now, the third prong of the test that Justice Shastri insisted upon was that the means must not only be reasonable, but they must also not be arbitrary, oppressive, or unjust. A balancing kind of a test, what you now know as the fourth prong of the proportionality standard. This was his third prong. The elements of this, he held, included the substantial requirement of justice should not be violated. Notice of the charge and of the inquiry should be given. Adequate opportunity to rebut the charge and to be heard in defense should be given. The tribunal must be impartial and disinterested. And any condemnation, conviction, or deprivation of personal liberty or property must be imposed only as a result or by the force of the decision of the tribunal. In this specific case, he noted that the provisions of the Act which did not require service upon the affected parties, where there was no time limit in sending the decisions of the government, the advisory board, and where numerous procedural safeguards were undercut, was ripe for abuse. And if a legislation enabled abuse in this way, then that made it unconstitutional. In effect, he said it was a bit like the law was placing the sentence before trial and judgment. And this is also important because we hear multiple times this whole rhetoric that the constitutionality of a law and the possibility of abuse are two different things. And if the law is abused, then you take your remedies before the administrative authority that's abusing the law. That is not a ground for holding law to be unconstitutional. Now that's very strained logic, and you can see that logic being undermined and interrogated in this judgment, because what Shastri J clearly says is that if the provisions themselves are so loose and so broad that you have to, being aware of the reality of how governments function, you can tell that abuse is inevitable, then that should not be a ground to not strike down the law, because then why would you put people through a process where they have to go to the authority to try and get abuse remedied in every specific or single case. Now, another provision, as I've mentioned before, allowed the government not to disclose material that it felt was not in the public interest to disclose. This is something that would later come in the EDM Jabalpur case and was upheld in the EDM Jabalpur case. And in this era of sealed covers, whatever the law is, it's pretty much part of, unfortunately, judicial practice. I recall being in the High Court, in the Delhi High Court once, and watching a proceeding where at issue was the UAPA, which, like the Criminal Law Amendment Act, enabled banning organizations. The ban upon a certain organization was challenged. And one of the arguments was that the register of the association that had been seized from its headquarters, if the names of the people who were members, they had no offenses against them. So none of them had a criminal record. But that register had been seized, and therefore the association could not rely upon that to prove its case. Now, during the arguments in the Delhi High Court, which this was a couple of years ago, the state said that it would allow the judge to view that document and the register, but in a sealed cover, and would not give a copy of it to the lawyer of the association itself. And so you had this bizarre situation where the lawyer for a banned organization was not allowed to see the material on which the ban was being justified, and therefore to contest it. And ultimately, the judgment upheld the ban, despite the fact that the lawyer for the association was never allowed to see the basis on which the ban had been imposed. So that's what's happening these days. And here, to come back to Vg Rao in the Madras High Court, Shastri J said in very clear terms, in this law, the persons affected are not entitled to know on what evidence they are being declared to be members of an unlawful association. The government is entitled to withhold communication of the evidence according to its discretion, even though it cannot claim privilege under the Evidence Act. It might be that during a state of war, when the very existence of the state is threatened, or under the Preventive Detention Act procedure, the government might not be required to disclose confidential information. But this is an exceptional procedure which does not admit of being made part of the ordinary criminal law and procedure. And on that basis, he struck down this rule as well. So you can see the very clear demarcation between what is meant to be normal and what might, in exceptional cases, perhaps be justified. The third concurring judgment of Raja Mannar J brought together many of these strands. And in summation, he observed, in deciding on the reasonableness of the restrictions, it is not possible to think only in the abstract. Several circumstances must be taken into consideration. In particular, the purpose of the act, the conditions prevailing in the country at the time, the duration of the restriction, its extent and nature. And then he goes on to say, what may undoubtedly be a reasonable restriction in a state of war or revolution may be utterly unreasonable in normal times. What may be a reasonable restriction if it's for a short period may be unreasonable for a much longer period. And then he also, with his brother judges, struck down the act. So thus, you can see that in three ways, the Madras High Court in Vg Rao's case engaged with what might have been thought to be unfavorable precedent in terms of Gopalan and Khare, and drew these three lines in the sand between the preventive and the punitive, the temporary and the permanent, and war and peace. And this is really important because, again, remember going back to this discussion about Gopalan last month, the original sin of Gopalan, as I tried to argue, was that it blurred these lines. It failed to see that preventive detention, even though it was in the Constitution, was always meant to be exceptional. And therefore, those constitutional provisions, the laws that were sought to be passed in the context of those provisions, had to be interpreted as if they were exceptional, and therefore it read narrowly, struck down if they went beyond a narrow reading of the provisions, and so on. Now, the Supreme Court in Gopalan didn't do that. And of course, the High Court in Rao's case was bound by that. So the High Court could not go beyond Gopalan. But what the High Court did do was that it restored this conceptual idea of this distinction between the normal and the exceptional, and that there must be a clear line, a defined line, that prevents the exceptional from bleeding into the normal. And thereby, these exceptional procedures, advisory boards, subjective satisfaction, not disclosing material, all these exceptional things that you resort to have to be confined in those defined categories. And this is not something that can be blurred, and this is not something that the courts can assess on a case-by-case basis. The lines have to be clearly drawn. That was the really important contribution of the High Court judgment in the Vg Rao case. One thing I would say that the High Court, perhaps, in my view, didn't do correctly was maybe engage with the Article 14 argument. Because M.K. Nambiar made a strong case that why is this special procedure being used to ban organizations, and the panoply of safeguards available to a criminal defendant isn't available to these associations and their members. And the court kind of dismissed the argument, saying that, look, the Parliament has the prerogative to choose the procedures it wants to follow for different kinds of crimes. And as long as it's fulfilling a basic threshold, which in this case it didn't do, it's fine. But I think what the court failed to engage with is that the very fact that you have this separate procedure being brought in just for associations of this kind, and clearly for political reasons, itself makes it look like an exception and affects the way in which adjudication takes place then on bans and so on. And judiciaries inevitably are more tempted to uphold these kinds of bans if the entire structure that is being erected is somehow separate from the normal criminal law structure. And so in that sense, I think the failure to properly engage with the Article 14 argument did help to entrench the whole Gopalan idea of the exception being taken forward and just, being at the prerogative of the legislature. But that's a small complaint. Broadly, the High Court's contribution here was immensely important. Now that brings us to the Supreme Court judgment. And there's nothing actually wrong with the Supreme Court judgment. It upholds the High Court's judgment, and the law was struck down. But the problem with the Supreme Court judgment is that this really fine-grained analysis that the Madras High Court did, and in many ways the way it restored that fundamental distinction between the normal and the exceptional, and thereby the primacy of rights in normal circumstances over restrictions, that gets completely obscured in the Supreme Court judgment. And so, for obvious reasons, what we do read is the Supreme Court, and nobody ever reads the High Court judgment that led up to that. So, in Vg Rao in the Supreme Court, in paragraph 15, broadly, the Supreme Court summarizes the High Court judgment. Supreme Court says that the learned judges of the High Court unanimously held that the restrictions under Section 15, Clause 2, Subclause B of the Criminal Law Amendment Act were not reasonable on the ground of 1, the inadequacy of the publication of notification, 2, the omission to fix a time limit for the government sending the papers to the advisory board, or the latter to make its report, no safeguards being provided against the government enforcing the penalties in the meantime, and 3, the denial to the aggrieved person of the right to appear either in person or by pleader before the advisory board to make good his representations. And he then goes on to summarize that Justice Rao held that Article 14 was impacted in a different way. Shastri J held that the forfeiture provisions were unconstitutional, and so on. So the Supreme Court reduces the High Court judgment to this really formalistic procedural judgment that X not done, Y not done, Z not done, unconstitutional, like a checklist. But as we have seen, the High Court judgment was so much more than that. It was so much more than that. It was about a conceptual analysis, an idea of the fact that the Constitution in most cases accords primacy to rights, and exceptions must be clearly spelt out in the Constitution itself, such as preventive detention, or if there is a war, which again, we have an emergency provision. So unless you have a constitutionally defined exception working, in all other cases, you have to give primacy to rights, and you can't depart from that basic principle. That was what the underlying philosophy of the High Court judgment was. The Supreme Court virtually completely obscures that and erases that by making the High Court judgment a procedural judgment about a checklist. And so, what does the Supreme Court then say? The Supreme Court then decides the case or upholds the High Court judgment on exactly one ground. And this is a little ironic because the Supreme Court first says that we are of the opinion that the judgment can be rested on a broader and more fundamental ground. But the actual ground is much narrower, because what the Supreme Court is worried about is that in the Criminal Law Amendment Act, there was a bar upon testing the factual and legal grounds of the ban before a court. And so the Supreme Court says that this law allows the executive government to impose restrictions on the right without allowing the grounds of such imposition, both in their factual and legal aspect, to be duly tested in a judicial inquiry. And that is a strong element which, in our opinion, must be taken into account in judging the reasonableness of the restriction imposed by Section 15, Clause 2, Subclause B on the exercise of the fundamental right under Article 19(1)(c). So what the Supreme Court was concerned about was that the court's role is being minimized in adjudicating upon a violation of rights, and fair enough, that's fine. What the Supreme Court doesn't say is what approach should the court take were it to actually judge that question. And that was the fundamental issue that was really grappled with by the judges of the Madras High Court. And that conceptual approach was what was occluded here in the Supreme Court. And so what effectively then the consequence was that a chance to confine the Gopalan judgment, a chance to confine the Khare judgment to their respective spheres as exceptional cases was missed. And the consequence of that was that over the years, as is inevitable, the exception has bled into the normal. And so you have the National Security Act, you have what earlier was TADA, then POTA, and then the UAPA, and of course, the Armed Forces Special Powers Act. And it's interesting because if you read the judgments that have upheld those laws, in those laws, there was those laws were punitive. It wasn't preventive. There was no state of war. These were permanent laws, not temporary. And in all these cases, you see the Supreme Court, when upholding these laws, begins to really stretch the idea of the exceptional. So in TADA, terrorism becomes this kind of overarching justification. And of course, terrorism has no beginning and has no end. So that is effectively what it's what we call a forever war, right? I mean, the Americans have been fighting global terrorism from 2001. It's 20 years now, no end in sight. So if that becomes the basis for allowing departures from these fundamental premises, and if that becomes the justification for allowing the restrictions to override the rights, then you might as well pack up and go home, because there'll always be that justification that exists. This is where that whole fable of Odysseus of tying himself to a mast becomes interesting. This is an old Greek myth where Odysseus and his sailors were sailing, and they had to go past this island of the sirens, and the siren song was such that if you heard the song, then you would be unable to not go towards them, and your ship would break on the rocks and you'd drown. And so what Odysseus did was he told all his sailors to cover up their ears and then tie him to the mast so that they could keep navigating, and he could direct, but he couldn't move and force them to go towards the sirens. So this whole idea that if you know in advance that a situation will come where then you will be tempted to do something that you in your moment of calmness know would be wrong, you take steps to bind yourself against doing that when that time comes. And this clean line in the sand that the Madras High Court drew, that we have these situations, war, preventive detention, and a temporary law, a defined sunset period. Those are the clean-cut exceptional cases. And of course, remember, it was forced to do that because of Khare's judgment and Gopalan's judgment. You have these three clean-cut cases, and in other circumstances, come what may, whatever the state says, whatever the arguments are, we will apply normal constitutional principles. And that ensures that next time there is a fresh argument, it's no longer Gopalan's preventive detention, it's not Khare's temporary law, it is now Kartar Singh's terrorism. You have already drawn that line in the sand that requires you as the court to ensure that those rights are upheld, and you don't carve out yet another exception that ultimately swallows up the whole constitutional rule. That could have been the way that jurisprudence went, and that then might have taken us to a more civil liberties oriented, progressive jurisprudence in the years to come. But the Supreme Court's failure to engage with that and to take that forward and to ultimately pass what was a procedural judgment in Vg Rao gave us a good outcome, but failed to ultimately craft a jurisprudence that would enable the judiciary to resist the continuing encroachment of state impunity. So in that sense, Vg Rao was a chance missed, but the High Court judgment and a careful reading of it reveals the possibilities that always exist and the possibilities we might want to try and resurrect in today's day, when again we are facing the whole issue of executive impunity through various broad laws and what courts can do to push back against that. So with that, I'll close. Thank you for attending. See you next month.